Hi everyone, it's me, Lauren Cadillac with Cadillac Law. I'm coming to you with more valuable information. Today we're going to be talking about how evictions can get messy and what you can do to prevent that. As always, however, anything we say here does not create an attorney-client relationship, and none of this is legal advice. I'm just telling you what I know, giving you pointers from what my experience is. In Texas, a landlord-tenant relationship, prior to COVID, was very pro landlord. But when COVID hit, things kind of shifted and it became pro-tenant for quite a while. We're moving back to being pro-landlord, and the black letter of the law is very pro-landlord. However, the legal system is managed and operated by human beings. And many human beings make errors. And many human beings touching one thing along the line can cause many errors throughout the process. So, things I have learned that aren't necessarily the law are things that we do in my practice. For instance, in Texas, a 30-day notice when there is no written lease, a 30-day notice to a tenant, or we'll say if the lease is expired or there's no longer a written lease, a 30-day notice is sufficient to go file an eviction. However, I have been in county court in an eviction appeal where we gave only the 30-day notice as required by law, as sufficient under the code, and the judge said, no, that's incorrect. You still needed to do a 3-day notice. So even though the law says that you do not need a 3-day notice, that judge, who is the one applying the law to the facts, said we do. So now in my firm, after that, you get burned once here, y'all. You get burned once. So I got that burned one time. We always do a 30-day, and then we do a 3-day. Even though it's not necessarily mandatory under the law, it is what we do because we want to make sure we're going to win. Evictions can get messy. You do anything wrong, and if the tenant knows, if the tenant understands the code, they can get out of the eviction. So again, the judge can also change their mind. I've been in eviction court where I overheard a judge telling someone, you don't need to kick her out, it's Christmas. And the lawyer for the landlord yells, we've been to this court since August. We've been trying to get her out since July. It is now Christmas because the court made it Christmas, right? That can happen, folks. The court is run by human beings. Ultimately, a judge is a human and they can choose to do as they please. So when you see situations like that one, you make sure you take note, and in your future dealings, you make sure you do that extra step. Is it extra to do the 3-day notice? Yes. Am I going to do it anyhow? Also, yes. Another important thing is that 3-day notice, not the 30, but the 3-day, needs to be in something that in big red letters says important notice. Okay, so I, as a practice, will put that in red letters, and then I photograph it, taped to the door, the inside of the door, wherever, because you got it. We got burned once. You get burned once, you don't let it happen again. You write that down and you make it part of your policy. So make sure after you've done the 30-day, when you're doing the 3-day, you've got the big red letters in the notice. If a tenant catches wind and they learn about that law and they realize you've done it wrong, I guarantee you're going to have to start over again. You can always just start from the beginning and hire a professional such as myself. Like I said, I've done this enough, I've got burned enough that I have learned many lessons, and I am usually able to successfully evict tenants, often without even an appeal because they know there's no winning. So if you have questions for us, please feel free to comment, make sure you like and subscribe, and we'll see you next time.